Hello friends, this is Dr. Krishna Desai, Assistant Professor at Vanita Vishram Women's College of Commerce. Today we are going to take up a small tutorial on the residential status of individuals under the Income Tax Act 1961. Now friends, we know that the residential status as well as incidence of taxation are two important aspects which are required to calculate the tax liability or to know about the taxable income of the assessee. In this tutorial, we are going to discuss about the provisions relating to determination of the residential status of individuals as per the Income Tax Act 1961. And by the end of this tutorial, students should be able to understand the concept of why determination of residential status is important and to know about the calculation of number of days of stay in India so that we can determine the tax liability on the basis of the incidence of taxation. Now, tax incidence basically of an assessee depends upon his or her residential status during the previous year. Now, when we talk about incidence of taxation, it means that whether liability of paying taxes will arise or not. So, incidence of taxation will depend upon the residential status and upon the type of the income which is earned. Residential status is determined on the basis of the provisions of Section 6 of the Income Tax Act 1961. Now, it is significant to determine the tax liability and that's why residential status is calculated. When we talk about residential status of an individual, residential status of an individual is divided into three parts. A person can be a resident and an ordinarily resident. A person can be a resident but not ordinarily resident. And a person will be classified or can be classified as a non-resident. Now, all these three classification of residential statuses will depend upon the days of stay in India of the individual assessee. For each and every year, we are going to calculate the number of days of stay in India in order to determine the residential status of an assessee. So it is not necessary that the residential status of an assessee will remain same throughout all the assessment years. Secondly, there are other taxable entities as well. In the definition of person which is laid down in the Income Tax Act, taxable assessee comprises of individuals, HUFs, that is Hindu undivided family, a firm, a limited liability partnership or an association of person. It also includes body of individuals, artificial juridical person, local authorities and other recognized bodies. Now, when we talk about residential status of all the taxable assessees, it is only in case of individuals and in case of the Hindu undivided family that their residential status is divided or classified in three components. That is, they can either be a resident and an ordinarily resident, a resident but not ordinarily resident, and a non-resident. Whereas in case of all other taxable entities, their residential status is divided either into resident or non-resident, which is quite evident from this chart as well. Moving on to determination of the residential status of individuals. Now see, residential status of individuals is going to be calculated on the basis of two steps. Firstly, we are going to apply the basic conditions which are laid down in subsection A(1) of section 6 of the Income Tax Act. And then we are going to apply the additional conditions which are laid down to further determine whether the individual is an ordinarily resident or not. So the determination of residential status for individual assessors is going to be divided in two steps. In the first step, we are going to apply the basic conditions, and in the second step, we are going to apply the additional conditions. And thereafter, we will come to the conclusion about the status, that is the residential status of the assessee. Now talking about the basic conditions. There are two basic conditions which are laid down in the provisions of the Income Tax Act. The first being that a person has to be present in India for at least 182 days in the previous year, which is relevant to the assessment year for which the determination of residential status is being done. So the first basic condition says that a person should be present in India for at least 182 days in the previous year, relevant to the assessment year for which the residential status is being calculated. Second basic condition says that a person has to remain present in India for at least 60 days in the previous year and a period of 365 days in 4 years immediately preceding the previous year. So these are the two basic conditions which are laid down. And if the person satisfies any one of the basic condition, then that person will be regarded as a resident. If none of the basic conditions are satisfied, in that case, the person will be classified as a non-resident. Now, for a non-resident, there is no need for application of the second step. But in case the person is determined as resident on application of the basic conditions, then we shall further find out whether the person is ordinarily resident or not. For that, we will have to look upon the additional conditions. But before that, there are certain exceptions to the two basic conditions which are laid down. In case the person is traveling out of India for the purpose of seeking employment, or if the person is a member of an Indian ship and he is deputed to work on a ship and that's why he is leaving India, or if a person is of an Indian origin and he comes to visit India in the previous year. So in these three cases, the second additional conditions will not be applied, and only on the basis of the first basic condition, the residential status will be determined. That is, in case a person is permanently moving out of India for employment purpose. Number two, if a person is a member of an Indian ship and he is deputed for a work and that's why he is leaving India. And number three, a person is of an Indian origin who has come to visit India. In these three cases, the second basic conditions will not be applied. It is non-functional and the residential status will be determined only on the basis of the first basic condition. That is, the person should be present in India for at least 182 days in the previous year. So this is regarding the exceptions. Yes. Now, how do we determine whether a person is of an Indian origin or not? So in case we have to find out if the parents or grandparents of the assessee were born in undivided India, then a person will be classified as a person of Indian origin. Apart from these exceptions, all the other individuals will be determined on the basis of the two basic conditions. And if any one of the basic condition is satisfied, a person will be classified as a resident. A resident individual can further be divided into an ordinarily resident as well as not ordinarily resident. For that, we will have to apply additional conditions. Now, there are two additional conditions which are laid down. First is that a person should be resident in at least 2 out of 10 previous years immediately preceding the previous year. And number 2, a person should be present in India for at least 730 days in 7 years immediately preceding the previous year. If both these additional conditions are satisfied, a person will be considered as a resident and an ordinarily resident in India. If any one of the additional condition is satisfied, or if none of the additional conditions are satisfied, then a person will be considered as a resident but not ordinarily resident. So this is how we are going to determine the residential status of an individual. Let us do a quick revision. The first and foremost question which may arise is, who is resident and ordinarily resident in India? So, a person who is satisfying both the basic conditions or any one of the basic conditions, and he is satisfying both the additional conditions, then he is considered as a resident and an ordinarily resident. The second question, who is resident but not ordinarily resident in India? A person who is satisfying either both the basic condition or any one of the basic conditions, but is not satisfying both the additional condition or is satisfying only one additional condition, then that person will be regarded as a resident but not ordinarily resident. And lastly, the residential status of an individual is divided or classified as a non-resident. So who is going to be considered as a non-resident? Any person who is not satisfying any one of the basic conditions will be considered as a non-resident, and in case of non-resident, there is no question of applicability of the additional conditions. So this is how we are going to determine the residential status of an individual. Thank you.